Secrets of the Social Security Number. Copyright 1993 by Frederick Mann, editor, all rights reserved. Introduction. The Social Security Number is an important weapon in the hands of the territorial gangsters, people who use deception, fraud, coercion, and terror to claim jurisdiction, so-called, over people who happen to be in a certain geographic territory. Territorial gangsters, TGs, love to create systems that enable them to dominate and control their victims so they can live off the fruit of their labor like parasites or cannibals. They use the Social Security Number to keep track of their victims. Other agencies, such as credit bureaus and banks, also use the Social Security Number SS# to identify people. The 14th Amendment to the U.S. Constitution created a creature called a U.S. citizen, euphemism for victim or slave. U.S. citizens are subject to federal and other statutory jurisdiction. The TGs took many other steps to turn individuals into victims or slaves. One of these steps was the introduction of the Social Security system. Practically all these steps have been flagrantly fraudulent. The TGs like to operate on the basis that because you've applied for their SS# and stated on the application that you're a U.S. citizen, you are their slave and they own you and can tell you what to do or what not to do. They won't put it this way, but this is the basis on which they operate. Read Report #04, How to Find Out Who You Are for a better understanding of this. We advocate that you shift your economic activities into the real free market. However, it may still be necessary for you to use an SS# or equivalent for certain transactions. So, the more options you have available to you, the better, the more easily you can operate in the real free market. See Report Number 01, Introductory Freedom Guide for details. We also advocate that people correct their status from the equivalent of a slave to that of a free sovereign individual. Understanding the nature of SS#, S or, for non-Americans, the equivalent numbers that are assigned and used in other countries is an essential step in this process. This report provides you with vital information to outwit territorial gangsters, TGs, and other bloodsuckers. Here are some of the areas covered. General information on Social Security. The Social Security Act. Comment upon voluntary nature of Social Security, legal brief by attorney Larry Beecraft. 3 kinds of TG-S, SSN, Social Security Number, EIN, Employer Identification Number, TIN, Taxpayer Identification Number. The structure of the SS# significance of first 3 digits, ranges assigned to each state, ranges not used, significance of digits 4 and 5, significance of last 4 digits. How to legally change your SS# copy of relevant TG policy and procedures. How to get a new TIN from the IRS, sample SS4 form, how to use your TIN number for credit applications. How credit bureaus identify you. How to establish a new credit file. The common law name principle. The Anthony Hargis method to terminate your SS#. Other organizations that help you terminate your SS#. General advice on operating without a SS#. Several ways to open a bank account without a SS#. Bibliography on SS# and identities. Information on Social Security misconceptions abound regarding a Social Security card and number. Like a driver's license, its intended use was simple and direct. A Social Security number supposedly represents your private account to hold paid-in benefits for your old age. It was essentially a coerced savings program initiated by Franklin Delano Roosevelt and was heralded at the time as a product of enlightened social conscience. Today, the Social Security system is broke, benefits provide a subhuman existence, and when it's time for you to retire, there will not be enough people paying in to foot the bill. So much for enlightenment. You've probably noticed that everyone wants your Social Security number these days. Schools, lenders, banks, everyone seems to want it. Why? Because it's an easy way for individuals and the government to identify and keep track of you. It's one number you're supposedly stuck with your whole life. Most people believe that the law requires you to have a social security number to work in the United States. As we shall later see, this isn't true. Nevertheless, the Privacy Act of 1974 requires that the SSN be provided for certain purposes. You must give your Social Security number to the Internal Revenue Service and the Social Security Administration. You are supposedly required to give your employer your Social Security number in order for your employer to prepare the necessary tax records for the Internal Revenue Service and Social Security Administration. In a nutshell, the law says that no federal, state, or local government agency may deny you any right, benefit, or privilege for refusing to provide your Social Security number, unless there is a law or regulation on the books adapted prior to 1975 that specifically authorizes the demand for the number. Your employer by law cannot divulge your Social Security number to anyone. In fact, the IRS cannot divulge your Social Security number to anyone. The only thing that the IRS can verify is if the Social Security number you are using is valid. That is why you may want to acquire a Taxpayer Identification Number (TIN) that is associated with your name. Then if anyone wants to verify the TIN with the IRS, they will state that the TIN is valid to your name and the IRS cannot divulge any other information about you. You are not required to give your Social Security number to anyone else, including creditors, hospitals, doctors, credit bureaus, or any other private firm that wants to keep track of you. If you have to give an identification number, you should have a Taxpayer Identification Number (TIN), which you may acquire as outlined in this report. See pages 14 to 19. This Taxpayer Identification Number can be used to set up your new credit file and for other purposes. This Taxpayer Identification Number (TIN) can only be acquired once in your lifetime, so be careful how you use it. If you want to try to secure a new Social Security number, it's possible, and the information on pages 13 to 14 tells you how. Unfortunately, it's a lot more difficult and time-consuming than getting a Taxpayer Identification Number (TIN). The Social Security ACT generally, dictionaries describe nexus as a connection, tie, or link between individuals of a group, or members of a series. TGs use the term to imply that someone is their slave in some respect. For example, a mail-order company operates from a certain state. The TGs of that state claim that the company has to pay sales taxes on sales made within that state. They have nexus in respect of those transactions. Generally, the company doesn't have to pay sales taxes on sales made to other states. However, under certain circumstances, the TGs claim that they have nexus even on sales made to some other states. For example, if the company has some kind of office or representative in those other states. But the main thing to understand is that when they say they have nexus over you, it means they regard you as their slave in some respect. The main purpose of the Social Security system is to turn people into slaves. The Social Security Act is a monstrous lie. It was created and devised and intended unjustly, fraudulently, and maliciously to deprive the individual of his/her birthright, good name and character, and to legally steal his wealth. Some people claim that the Social Security Act was a plot to rid the individual sovereign of his absolute rights, and, further, that the underlying purpose was to render the individual subject to, and the object of, the tax laws and other related contractual obligations. The Social Security number is recognized by other nations and is prima facie evidence that 1. The numbered citizen is a card-carrying and practicing member of socialism. 2. He has voluntarily waived his absolute right to a personal security. B. Personal liberty. C. Personal property. 3. He can now qualify and expect to receive protection, security, old age benefits, minimum wages, food stamps, and welfare benefits from the government financed by the society at large. 4. He is now under public policy for the good of the whole and is allowed to keep only according to his needs after all his claims and deductions. 5. He is a taxpayer within the scope of the IR Code. 6. Some of his constitutional protection, Bill of Rights, no longer apply. 7. He has denounced his sovereign status of a free person, and is administered through a regional district. 8. He is a taxpayer and a collector of his own tax, and can be labeled a tax cheater, a tax protester, and a tax evader if he does not file. 9. He subjects himself to the United States Congress and can be charged criminally for willful failure to file. 10. He has rejected the natural laws or common law, and he has exchanged his blessings of liberty for a mess of pottage. The organic laws of contract are now in force to compel him to abide by his hidden agreements, imposed by his participation in the Social Security system. What is a conspiracy? A conspiracy is a combination, usually secret, of persons for evil or unlawful ends. Blackstone further stipulates that in law, conspiracy is an agreement between two or more persons, falsely and maliciously to indict, or procure to be indicted, an innocent person of felony. The most approved manner of charging the conspiracy are the words, did conspire, combine, confederate and agree together. The Social Security system is a conspiracy to enslave the innocent. The following are excerpts relating to the Social Security Act. They are from the Social Security Laws, 98th Cong. 2nd Sess. Committee print through April 1, 1944. To provide for the general welfare by establishing a system of federal old age benefits, and by enabling the several states to make more adequate provision for aged persons, blind persons, dependent and crippled children, maternal and child welfare, public health, and the administration of their unemployment compensation laws, to establish a Social Security Board, to raise revenue, and for other purposes. 74th Cong. Sess. I. Ch. 531 H.R. 7260 Pub. Law No. 271. When used in this act, the term person means an individual, a trust, or a state, a partnership, or a corporation. 49 Stat. 620, 647, 1935. The term taxpayer means any person subject to any internal tax. 26 U.S.C. 7701, up 14. The tax imposed by Section 3101 shall be collected by the employer of the taxpayer, by deducting the amount of the tax from the wages. Title 26, IRC. Sec. 3102. Employment. For purposes of this chapter, the term employment means any service for the person employing him, irrespective of the citizenship or residence. Title 26, IRC. Sec. 3121. Following are additional excerpts from Title 18, USC and Social Security Case Law. The District Courts of the United States shall have original jurisdiction. Exclusive of the courts of the states, of all offenses against the laws of the United States. 18 U.S.C. Sec. 3231. Rule 54. Special maritime and territorial jurisdiction of the United States defined. 18 U.S.C. Sec. 7. Rule 54. Willful failure to file return, supply information, or pay tax. 26 U.S.C. Sec. .7203. To sustain a conviction, defendant must have been a person required to make return, and his failure to make return must have been willful. United States v. McCormick, 67 F.2d 867, 2d CIR. 1933, NY. Conviction under 26 U.S.C. Sec. 7203 is obtained on proving that defendant knew of requirement to file return and willfully failed to do so. U.S. v. Klein, 438 F. Sup. 485 SDNY. 1977. Willfully means no more than voluntarily, it means an act done with bad purpose, without justifiable excuse, without regard for believing act is lawful, or conduct marked by careless disregard whether or not one has rights to act. Congress did not intend that person by reason of bona fide misunderstanding of his duties should become criminal by his mere failure to measure up to prescribed standard of conduct. U.S. v. Murdoch, 290 U.S. 389, 78 L. ed. 381, 65 S. Court 223, 1933. Willful requirement with respect to willful failure to file return means act both intentional and reprehensible, attended by knowledge of legal obligation and purpose to prevent government from getting that which is lawfully required. U.S. v. Vitiello, 363 F2D, 22 ALR 3D 1161, 3D CIR. 1966, N.J. Willfully generally connotes voluntary, intentional violation of known duties. U.S. v. McCorkle, 511 F.2D 482, 7th CIR. 1975, ill. Privilege against self-incrimination is not defense to prosecution for failing to file federal tax return, but privilege can be claimed against specific disclosure sought on return. U.S. v. Garner, 424 U.S. 648, 47 L. ed. 2D 370, 1976. Bad faith or evil intent and want of justification in view of all financial circumstances of taxpayer are necessary elements of willfulness in criminal tax case. U.S. v. Swanson, 509 F.2D 1205, 8th CIR. 1975, Iowa. Element of willfulness involves a specific wrongful intent, namely, actual knowledge of existence of legal obligation and intent to evade that obligation. U.S. v. Thompson 230 F. Sup. 530, 338 F.2D 997 D.C. Con. 1964. Defendant's conduct is not willful if he acts through negligence, inadvertence, or mistake, or due to his good faith misunderstanding of requirements of law. U.S. v. Rosenfield, 469 F.2D 598, 3D CIR. 1972, Pa. In all the above named cases, the evidence before the court was 1. The person was a taxpayer. 2. A numbered person. 3. A person, as defined under the IR Code. 4. A defendant. 5. A person chargeable. 6. There was a viable nexus. 7. A person who was obliged to perform under a prescribed standard of conduct. 8. Had a legal obligation. 9. The common law of contracts was applicable. The terms, people, or human being, are not to be found in the Internal Revenue Code, and it fails to properly identify who is required to file. It cannot be found because it is not there. Partaking into the Social Security Act merely identifies one as a person who is receiving benefits and therefore must meet the burden. Under the ancient concept of Lord Mansfield's maxim, that no man shall enrich himself unjustly at the expense of another, in the eyes of the court, that individual ought to pay the income tax. The common law of quasi-contract, as if a contract, is now in full force and effect. The signature of a person is the proof of his consent that binds him under the law of contract. Nexus is defined as a connection, tie, or link between individuals of a group. The signature of each person, given voluntarily, binds the U.S. citizenry together into a lifelong socialized contract with the government. The law cannot be invoked when a citizen is not numbered, receives no benefits, and does not enrich himself at the expense of another. Without the law, the court cannot offer a remedy. When a court cannot offer a remedy, the court lacks jurisdiction. Under the Social Security Act, the citizen is in a state of voluntary servitude. Involuntary servitude is unconstitutional, 13th Amendment, but voluntary servitude is constitutional. For every positive action there is a negative reaction. One has the absolute right to enter into a contract and bind himself to specific performance, submitting himself to the law of contracts and to the laws of the contract. Within the U.S., and any place subject to its jurisdiction. No one can force a citizen into a state of involuntary servitude unless for the punishment of crime, whereas the party shall have been duly convicted. 13th Amendment. No one can force a citizen into a contractual agreement. The judicial, executive, and legislative branches of the government do not have that power. A tax judge will always remind a litigant that there are no constitutional protection, i.e., right of free speech, privacy, in a tax court when under contractual obligations. But no judge can order a citizen to participate in the Social Security system. The system is 100% voluntary, and whoever joins the system also volunteers into paying the income tax. The following case law describes a valid, constitutionally valid tax return. Taxpayers' Internal Revenue Service 1040 forms containing only asterisks denoting constitutional objections constituted returns, as a matter of law under 26 U.S.C. Sec. 7203. U.S. v. Kimball, CR 860017, 1990. A sentence compelling a citizen to join under the Social Security Act is not a remedy. It would be an act of judicial abuse, as a court lacks the authority to do so. Such judicial indiscretion is appealable. Compelling a person to obtain a Social Security number is also invalid. Litigation will only be allowed if the accused had a Social Security number prior to the investigation and litigation. Where a person has been induced by fraud to make a contract, several alternatives are open to him. He can treat the contract as valid and sue in tort for the fraud. He can rescind the contract by proceedings in equity, or he can wait until sued upon the contract and set the fraud up as a defense. But at all times, when the fraud is discovered, recovery can be had. American Law and Procedure, Volume I, Contract. Evidence that taxpayer knew he should have filed tax returns, but had made no effort to pay his taxes or get in touch with any official about his income. Put question of criminal intent for jury. U.S. v. Sullivan, 98 F.2d 79, 2d CIR. 1938, NY. When a fraud is discovered, the plaintiff must put the other party on notice of the fraud, as it applies to his case, and if he benefits from the fraud, no recovery can be had. When the party himself rescinds or repudiates the contract, he merely gives notice by that action to the other party to the contract that he does not propose to be bound by the contract. This he may do by his own action, and he needs not turn to the courts. When, however, a court of equity grants rescission or cancellation, it wipes out the instrument, and renders it as though it did not exist. In effect, it tears up the paper and destroys it. A bill in equity to obtain a rescission is not like an action at law brought on the footing of a rescission previously completed. The foundation of the bill is that the rescission is not complete and that the plaintiff asks the aid of the court to make it so. A no. 95 ALR 1001. Neither an agent of the government, nor a judge, nor a legislative officer, nor an executive officer, can cancel participation in the Social Security Act of any citizen. Nor is there a provision within the code that permits and/or does not permit a citizen to withdraw from the system. These provisions are lacking because participation in the system is a voluntary contract decided by the individual. All citizens who have rescinded their Social Security numbers by resorting to common law proceedings, i.e., by the mere filing of a document of asseveration recorded in the county courthouse, will most likely not be recognized by a court that proceeds in equity. But if the word fraud is implied, he can wait until sued upon and set the fraud up as a defense. If the relief asked is in equity, then he who seeks equity must do equity, be given equity. The remedy that exists within the law must come from equity. Equity, that part of law which administers and adjusts common law rights where the courts of common law have no machinery. The following legal maxims are relevant to the above issues. He who affirms must prove. If the plaintiff does not prove his case, the defendant is absolved. The burden of proof lies upon him who affirms. Comment upon voluntary nature of Social Security, by Larry Becraft. Today, every day, Americans are constantly confronted with greater and more frequent requests from all too many sources that they provide to the inquiring parties their number of the beast, the Social Security number SSN. The examples of this modern-day phenomenon are numerous and known to all. Many states are now moving to ostensibly require the display of SSNs upon driver's licenses. Public school officials demand that school-age children obtain SSNs before those children may be enrolled in any public school. Private parties of all kinds, from banks to employers, deem it essential that they obtain the SSN of everyone with whom they may conduct any business. With all these entities making these demands, surely, the law must contain a requirement that everyone have the number of the beast. Of course, there are a few cases which recognize objections to the SSN on First Amendment, freedom of religion, grounds. See Stevens v. Berger, 428 F. Sup. 896 EDNY, 1977. Callahan v. Woods, 658 F.2d 679 9th CIR, 1981. and Callahan v. Woods, 736 F.2d 1269 9th CIR, 1984. Or, is it possible that everybody simply acts like lemmings, dutifully following the herd instinct without any question, assuming such requirement without any knowledge of it? More simply put, does the law demand that everybody apply for and obtain a SSN, or is such purported obligation nothing more than so much male bovine feces? B.S. The first inquiry regarding the legal duty to apply for and obtain a SSN must involve an examination of the U.S. Constitution and the powers granted therein to Congress. Congress can only possess powers which are contained, expressly or by necessary implication, within the text of the Constitution, particularly Art. 1, Section 8. Being straightforward and to the point, the problem here for Social Security is that no particular clause in this or any other article of the Constitution is sufficient to sustain such power to compel a domestic American to participate in a compulsory retirement or benefits scheme. The power to thus mandate participation in Social Security must therefore be one which is based upon an implied power. To determine if this power is one arising by implication, a study of various Supreme Court cases regarding the limits of congressional power is essential. The states are arguably the governmental entities which might possess the inherent, municipal power to compel participation in a retirement scheme, but, if the states might have this power, an issue which appears to not have as yet been decided, does Congress have a corresponding power? Can Congress assume this inherent power of the state and claim it as its own? Examples of Supreme Court cases which place some real limits upon the powers of Congress are manifold. In the license tax cases, 72 U.S. 462, 1866, the Supreme Court held that Congress could not authorize the conduct of business within the states in order to tax that business. In U.S. v. DeWitt, 76 U.S. 41, 1870, the court held that a penal regulation in a tax act could not be enforced in a state. In U.S. v. Fox, 94 U.S. 315, 1877, the court held that the United States could not receive property via a testamentary devise contrary to state law. In U.S. v. Fox, 95 U.S. 670, 1878, a penal statute remotely related to bankruptcy laws was held inapplicable in the states. In Patterson v. Kentucky, 97 U.S. 501, 1879, the court held that U.S. patent laws conferred no superior rights within the states. In U.S. v. Stephens, 100 U.S. 82, 1879, federal trademark legislation unconnected with interstate commerce was held inapplicable inside the states. In Baldwin v. Franks, 120 U.S. 678, 7S Court. 656 1887, certain penal, federal civil rights legislation was held unenforceable, within a state. In Ex parte Burris, 136 U.S. 586.